That's okay.
So anyway, that little house, that was replaced, the first one burnt down.
Oh,
There was
why
a
would they-
two-story there before,
Oh, really?
but I don't remember exactly what it looks like, but, yeah, I don't, long time ago, but, so that one was newest,
Okay.
the little house.
Yes, it's gone through lots of different businesses, hasn't
Yeah.
it?
Hey. What's your name? I forgot it.
I don't know. Yes.
Yeah.
Hey, Holly.
Yes,
That's
that's
good.
the picture.
It's Holly,
That's
right?
easy.
Yeah.
That's a good
All right,
Yes.
Holly.
Yes.
See, this
Are you putting this on Facebook Live or what are you doing?
It's not live, I'm recording on the village phone.
Putting it on where?
On the village
I
phone,
don't know where they got them.
we're recording it for the village.
Well,
It's a public hearing.
You know, the
I-
county, I don't know
Okay.
where they got all.
And you're gonna have it on the village?
I don't either,
website?
but I know.
We weren't planning to put it anywhere.
Right.
Yeah.
This is way before pixels were, so
Yeah.
they've got good film and prints and good printing. So I can work with that. The biggest problem is working with stuff. Because the one that I have on this one is cut off on part of it.
By the way, I wanted to tell you.
That was
Would
the
you-
route you're gonna get.
Right, but would you put it in as that, saying they're gonna restore it to a screened-in porch? Because I'm hoping they're gonna put
I could
it
have
to
real
a
potential.
regular porch.
Had you not?
Away the other way. I mean, that's just my purpose, it's not like.
All right, well, if you know anybody else who wants to.
I'll put the word out.
But that
Otherwise,
picture,
you know, I'm
there
gonna,
wasn't one,
I'm gonna
right?
have, we're gonna have to move.
The first
it.
one, there was not.
Like, I was
So
thinking
that's
maybe like.
really not an issue.
I guess
But
we
I
have
think
one
the porch
side
looks
of it.
nice, but
Yeah,
if
that's
they
just-
decided
Is
not
that
to,
Halloween?
we can't really say.
Oh, no, of
I was
course
thinking
not.
about this.
But it's also getting.
I mean, I wonder if he's seen it.
Just offer today, it's yours. And then if nobody makes an offer, we just go to the trailer, and get where it's gotta go next. Really need the.
The owner.
Million,
Those glass tables, we don't need those at all.
You got some beautiful stuff there.
We had some beautiful stuff.
But yeah, so I don't know if he's planning on putting the porch there. It's all gone.
Were you sold the address?
Yes, yeah, so, I mean, it just would be nice, cause it's
If he was gonna
a.
restore,
and remodel and refurbish, you know, there's all lots of.
maybe if he restored to that old picture.
That was not included.
That would be, because that had all the gingerbread and.
Yes.
It looks like a different color.
I'm.
Coloring it, like it, no, it's mostly, back in those days,
They did use a lot of colors.
might have had color. I don't know if there's any crazy stuff. Yeah, we're talking all black and
Here's-
white pictures.
Here's the most recent we have of the house. And
That's not gonna sell.
no, of course not. You know, I was looking at what I've got to look to say, okay, do you put in the after? Do you put in, because they're in the middle of it.
I don't think it matters first. I think it'd be best to put this in and
Yes.
leave it at that.
The best picture you can get, as far as I'm
Because
concerned.
that's the whole idea.
Here's the original, let's see, this is from.
Yes, that, so see how the shading is? So I'm guessing that that was probably a painted lady.
Joe, and I think of that as being shapes, I think of that as being,
Yeah, it's
Yours is
gingerbread.
pink, yes.
And that.
Could-
you-
yes.
You can see it's different
Yes.
colors, so
I've been to some launches.
it probably was a painted lady, just see if that was run back.
Gotta know what to
See,
paint.
that
if
would
we
be
wish
pretty
this
cool.
were horses were all the
Because
races.
They do a lot of that in Elgin. There's a lot of
They
painted
do,
ladies.
they do.
So, I mean, that's pretty cool.
It is, but this is better to
Yeah.
submit because it's clearer. Whereas this is more fun for this.
What did they have? They did have a little porch though, right?
Is a little front
Porch,
porch,
right,
right?
right there.
And it, looks like a.
Who else is supposed to be on there? It's it. So you only
This
have.
looks like a cutout, or is that something behind?
Neil, Phil, Christine.
Well,
Cause that looks like a porch on the side, doesn't it?
no, it's probably a bay window.
Because there's a set of stairs going up to that.
We're fine.
I don't think it, did they do bays back then?
Well, that's
Yeah,
gonna be
well,
unfortunate.
Cause
it's
this
not a
one-
bay like we know,
Can't do
but,
anything.
But this, cause
Like the
this
other
has,
houses
this is
that-
where the side entrance would be. which is
Right, it
right
might
there,
be.
but that looks like it's got an
Probably a
overhang.
side,
It's a
side
side entrance with an
I
overhang.
get the pay to be here and nothing
Well,
gets
I'm
done.
not sure where, it looks like it's before the window. Looks like it's
It's-
sitting before that. I don't know, that's a good question. I'd have to go look.
It's real,
But see, the
Tight
wraparound
staircase.
goes all the way over there.
right,
So,
so they would have
see,
done,
there's
this.
two doors.
Right,
There's a door, so
right,
there's
that
chances.
staircase they built.
So that goes to a side door.
and that had an overhang here, so they just made it connected.
But they might have changed it when they put the porch on. That's kind of what they did in my house, they put the front porch on.
They did it once.
Well, they tried.
They took out the two front windows, and put in a leaded
You know what?
glass window.
Oh, all right,
That's
okay.
not original, but
I
they,
see.
and then my house had side nets around the front door.
How did you know, old pictures?
I wish they would.
Can I help you?
So what, you know, about this wide, I have one.
Public hearing?
Still have one.
Yes, right here.
Yes.
Where's the big one?
Can you get in?
All the way, so the top was probably
Oh,
transom.
all right,
And they had to take that out when they put the porch.
and Rich's grandfather's house.
Big boys are.
We went down to the old building that they used
Here,
an
I'll
old
just,
door.
I'm just giving this one
And
in
it
plenty of
was,
space.
Etched
Yes.
scene of.
There you go.
And they needed a door in this chicken coop or whatever.
So I still have the
So
door.
we,
Yeah, the
we
original
did
door,
that,
the
yes.
it's actually a flower.
Me too, we've got
Really-
Bruce, and
really
it's,
cool.
and I had a stained glass artist make it,
Hey,
add
cheers,
to
y'all.
it, and we had a big panel,
Hi, haven't seen you in a while.
so. Is.
We weren't sure which thing.
Oh,
I think
no.
about that's original floor. So anyway, but that's the only,
Are those stiff back ones better for you?
What do you say is going
they,
Are the stiff back ones better for you, which you would prefer? I was gonna bring it over here,
Oh, shit.
whichever one you prefer. In fact, why don't we just bring it over, then you can choose between the two, if one gets more.
they didn't do too much, it's, the side porch is original. I have a side porch.
Oh, cool.
Oh, sure, no problem. Oh,
They should be able to take care of that. You're not supposed to die for
all right.
That's it, right?
Anybody who wants to make public comments, they should sign in on the paper that's in the front there, right here on the front table. And also, please do that.
On the front table?
Here,
Right,
this
no,
table
front.
right here, I guess, I
Here.
thought it was over
She was
somewhere.
walking over there.
Yeah, I thought it was
Sorry.
over there too.
What's going on?
Going whatever, they point me too, so.
And she asked.
Well, Jerry just asked, that's why.
So,
Send me a nine.
Jerry, we're not speaking, right?
Yeah, each of you two speakers.
The other Joe, he's not coming?
No, this is it, I think,
Okay.
right?
Yep, all right, so we get signed in, we'll get started.
Name tag?
All right, go ahead and call the meeting to order. I think what we will do, before we do roll call, we'll change the agenda and put the public comments after the roll call, and then we'll go to the public hearing, so people don't have to wait for hours to make a observation or whatever. So we'll switch that up, and all. Otherwise, why don't we go ahead and first do the pledge of allegiance, and then we'll roll call. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, let's have roll call, please.
Commissioner Dragoon,
Here.
Here?
Absent is Commissioner Joe Carpenter, who has notified us that he will not be present.
Very good. And I'd like to welcome Neil Anderson to the commission. It's your first time here, so I don't want any trouble.
That's
I'm
why
sure
I'm-
we don't have name tags up here, but we have Joe Dragoo down here, Peggy Sue Sheehafer. I got dyslexia when it comes to pronouncing names, please know that. Neil Anderson, I'm Jerome Johnson, and this is Carmen Forte, who is our village attorney. And so with that, we'll go ahead with any public comments. Do we have any public comments?
I'm gonna sit there in my public comments.
State your name and address.
All right, John Pree.
A former commissioner.
782 Hunters Hill Drive, Village of Campton Hills, 60175. With a chair. Yep, I resigned from this commission. Hey, we used to have name tags, that what happened to
Yeah,
name
that's-
tags? We could- I'm telling
Haven't
you.
gotten around to it.
At least we now got the big place instead of that big room, a little room. Congratulations, you're moving up. All right. Yep, I used to be on this commission, I got some things to say. First, the one big mistake that this plan commission made while I was here. One big mistake. We voted 3-1 to change the open space on the east side of Campton Crossings to be 2 commercial lots instead. That was bad. Fortunately, the village trustees woke up and stopped that and saved that open space. I understand what's going on. That's very valuable land on the east side of Campton Crossings there. But it's valuable for open space. I hope that stays open space forever and that we don't lose that open space or any other open space. The best open space we get is not the one we pay for, it's the ones that the developer gives us, right next to other houses and stuff. Let's not lose any open space that's given to us by a developer. All the open space we pay for, that's okay too, but we're paying for it, we should get it. Oops, that open space on the other side of Campton Crossings is coming back to this commission within a year or two, I guarantee it. It's coming back because it's all about money. I could talk on this one for an hour, but I'll move on. Lots of things come in front of this commission. Some of them are good ideas, some of them are bad. Try to figure it out. Another one. Lawyer, we got a new lawyer. Our previous lawyer, I objected sometimes because he was not giving legal advice. He was giving advice as to what our village needed. Our opinions as to what this village needs are just as good as the opinions of the lawyer. So if our lawyer starts giving opinions as to what should be in this village, his opinions are no more valuable than yours. He's only a lawyer, he should stick to legal issues unless the commission's opinions about everything else other than legal issues should be more important than what the lawyer says. I just added that. Next one. All the other votes that I ever participated on, other than the one I previously mentioned, all the other votes were super correct, super. We did a heck of a good job for a long time. Including that zoning ordinance that was so controversial. If you want my opinion about anything, my phone number is on the internet, 630-631-9141 if you have any questions. Last, My wife and I were blessed to live in 5 great towns. We didn't live in some places like Gaza Strip and a few other places, overcrowded, desolate. Lived in a great place. Campton Hills is by far one of the best ones, because when you come from the east and you're coming down 64, you go by all of that open space, the bike trail on your right, the Fox Mill open space, and even the Arbor Creek open space, and Campton Crossings open space. Beautiful coming in from the east. No other village has that. And then as far as other open space, you come in from the north on Corn Road. nothing is nicer than as you come into Campton Hills, Corn Farm, and the Forest Reserve. And as you come in from the southwest, you have Headwaters. And as you come in from the southeast on 38, you have Garfield Farm and so forth. You can't beat the rural area that we have here. My wife and I came in this direction to be more of a rural area instead of Hoffman Estates. Hoffman Estates was okay, but it sure was not semi-rural. We enjoyed this place for 45 years. And now I'm out of here. You will find me in Campton Township. That's where my legal residence will be, and where I will be voting maybe. And Naples, Florida, and a few other places. All right, thanks for listening to me.
Thank you, John.
Well, thank you, John, for your service. You were involved with the incorporation of the village, and I remember serving with you on the agricultural farm committee, advisory committee.
Yeah,
And
so none of you got to be here at the beginning as far as the planning commission. And there's only one person on the village trustees who's original too, and that's Michael.
right.
So,
Well, we
Yep.
certainly appreciate your service, and we certainly extend our sympathies to you with the loss of your wife and all. And we will miss you and hope to see you as frequently as possible. So again, thank you.
Okay, if you get into something controversial that I don't think it's gonna keep Campton Hills semi-rural, I'll probably show up, okay?
All right. I hope so. Okay, any other speakers? Any other comments? Mr. Chair?
Yeah, Mike Carroll. And John, I was first on the list, so you stole my thunder, but I wanted to acknowledge John as an original on this planning and zoning. There is no committee member who has served more years and given as much as John. And again, if everyone would just nod to John, thank you, John, very much. We wish you all the best in your next phase. Thank you.
They're here. Any other public comments? Yes, please. Your name, please.
So, my name is Julie Vaccaro. My husband, Bill Pasquale, and I live at 39W815 Goldenrod Drive in St. Charles in the Prairie Lakes subdivision, directly behind the property at 39W910 Old Burlington Road. We have a direct view of the back of this home and the current wall and area where the residents park their vehicles and trucks. We are pretty concerned about the large unattached garage that's proposed at this site. The ordinance, as we understand it, states a maximum of 900 or 910 square feet for any outbuilding. The proposal exceeds the ordinance by about 1,140 feet. In addition, the height is 20 feet. So this new building is the equivalent of a 2-story, 4,000 square foot home, if you were at 20 feet, right? Unless we have the dimensions wrong from what we were given, it's pretty large. We object to putting that size of a building in the direct line of sight in the rear of our home. As with most of the homes on Goldenrod in the Prairie Lake subdivision, they have 3 stories because they all have walkout basements, and they're all windows. For, second, first, and basement floor. The original builder did put up a berm, there is a very large berm that runs, the length, but the berm sort of ends at my house, and so we have a direct line of sight. They can see us, and we can see them. So we are worried about the size of the structure of this. As again, it's as long as we're understanding what the size is, what, you know, pretty sure I understand the math. It's pretty large. And during the fall and the winter and the spring, of course, there are a few evergreens, but they're mostly deciduous trees, and right, the leaves fall and you can see through everything. So we are asking that either the variance be denied or somehow altered, to not put such a large structure up. We just installed an in-ground pool spa last year, and we spend much of our time out in the summer, out there, you know, enjoying that. And a large building would impede our view, ruin our view, you know, and it would really, impede our ability to enjoy our outdoor space. We do have a couple of pictures for you, if you want them, from our.
Well, I'll tell you what we do, since we will open up, the hearing.
Okay.
And then we can already include her comments that's already been made.
Okay.
And all, but then you'll also be able to, share those with us at
Okay.
that time.
Great. All right.
And all, so I
Thank you.
appreciate it, and but we'll put it all together in one so everybody knows.
Okay, great. Thank you.
Thank you. Anybody else? All right, next, public hearing, I want to, have a motion to open, public hearing.
So moved.
All right, and a second,
Second.
all in favor?
Aye.
Aye. All right, okay, so, Mr. Bautista, is requesting a variation for a total square footage of a detached accessory structure and also a side yard setback for accessory structure in order to construct a freestanding garage. What we will do is we will have this staff explain, or in this case, Mr. Forte. I'm sorry, we just met technically. Mr. Forte, to explain the basic facts and the relief requested in the petition. Then it'll be time for the applicant, Mr. Bautista, or his representative, to present his petition and the testimony of witnesses and other evidence. And unless if there's important questions during his explanations and such that better clarify something, we will hold off questions from the body members here. And then there will be any public testimony and comment, general, and then, which is an example of Mrs., what was the last name?
Vaquero.
Vaquero, and all. And then after that, testimony, evidence, and questions, and then any other responses, questions by the members, and then at some point, we will close the hearing. Do we go to finding the facts?
After you discuss the motions.
All right, and all, and such. So, that's the procedure, and so with that, I will turn the microphone over to Mr. Forte.
Thank you very much, Chair. As indicated, my name is Carmen Forte, recently appointed as the village attorney, so I'll be joining you in the future. In addition to tonight, thank you for this opportunity, and I look forward to working with you in the future. For tonight's meeting, just to kind of differentiate from what you're typically used to seeing, it's not a full staff report, since I'm the village attorney and not, for instance, the building zoning officer or something of that sort. As Mr. Pre indicated, I can't provide recommendations on what suitability of a project, but I can provide you the legality of the process and what we need to discuss tonight. So, and that's what I tried to do in my report that I provided to you last week. We have two sections of the village code of the zoning ordinance that are under consideration tonight. One is for maximum square footage for a detached accessory structure, so a structure that is utilized to further the use of the primary structure. In this case, it's a single family home. and it's detached, so not attached to the single-family structure. The pertinent code section indicates that within a property of 2 acres or less in total lot area, which this lot is, it's 1.56 acres, I believe. The maximum square footage is 900 square feet. The application is seeking a variation from that section to allow for construction up to 2,040 square feet on this structure, so a variation would be required. It should be noted that I indicated in the report, the structure is indicated as 20 feet in height, and that would be permitted in this district. That's in compliance with the maximum building height allowance in the zoning ordinance. The proposed accessory structure will not exceed the maximum building coverage in the lot. It's an F district, which is typically more allowing of structures being placed on it, typically because in F district properties there are more accessory structures. In this case, it's 60% of the property can be covered. This comes nowhere near that. You typically see more restrictions in a residential district. The second section is setback requirement variation. The code requires 10 feet from any lot line unless further permitted or restricted by the ordinance. This property as constructed is proposed to be 2 feet from the side yard lot line. So not a rear or front, but side. I believe, if I'm not mistaken, it's to the, if you're looking at the home, it's to the left side. Excuse me. So that would be approximately 8 feet from the required setback. That's required in the code. I gave a description of the variation process in the memo. I can certainly answer any questions throughout the hearing, but the findings that are, the standards that are required to be considered by the commission, well, really by the ZBA, or Joint Commission ZBA, are included in the zoning ordinance and listed in this third page of my memo. The applicant will likely address these in their presentation. You may hear testimony from members of the public as to why they don't believe that those conditions have been met. You may also hear from the applicant why they have been met. I can't really give you an answer as to whether or not I believe they've been met. And I can provide you the legality of the process. And then it will be up to you to determine what your recommendation will be this evening. So there are conditions that you probably have seen that were indicated in the application that have been proposed by the applicant. Those came up, as far as I understand, through a zoning enforcement action. So the owner was cited for certain activities on the property, and they worked with staff, building zoning officer, to come up with proposed conditions that would prevent them from being cited any further. They also included that in their application as proposed conditions if a variation were recommended to the village board. The applicant will discuss those tonight, but I believe that they would agree to those conditions as entered in the draft. So you can certainly include those in your recommendation. You can add additional conditions. You can remove all of them or some of them or modify them. That's completely up to you. Based on your discussions tonight and the motion that's made, I'll prepare findings that you'll approve at a future meeting that will then go to the village board. I noted in the report tonight a positive recommendation, any recommendation, will require 4 votes. I know we only have 4 members tonight, but would require the concurrence of all 4 of you for any recommendation.
All right. And I should have mentioned this in the beginning of some introductory remarks as well. Just so everybody knows, this group, which is all volunteers that are appointed by the president of the village and then agreed to by the village board, that we make recommendations. We do not approve or disapprove. That is up to the village board to make that final decision. So we simply make recommendations. One can pursue beyond whatever our decision is, and all to the village board, so it's not, just a stop, dead end or anything like that. But with with that, the main role that we play, we're the first, in effect, public body, because typically petitioners first talk to a member of the staff responsible for helping to guide them through the process of what this code is, and then we as a body, they can approach us to have a presentation and information coming back from us as a public entity, specifically, that would give interpretation or an understanding of what the code is as it is presented, and then of course making the recommendation to the village board. So that's a little bit about what our role is and all. So with that, let's go ahead and what we need to do, anybody who is going to provide testimony tonight at this hearing, that they need to be sworn in. And so with that, anyone who wishes to speak in favor of this, please raise your hand, and we'll have Mr. Forte swear you in. And all.
Do you solemnly swear to tell the whole truth and nothing but the truth, so help you God?
Very good. All right. So, with the petitioner who is doing the presentation.
Would you want me to stay seated here or sit there?
Whatever.
Does it matter?
I'll just sit here in front if you'd like. And all. Yeah, go ahead and sit here in front.
Good evening, commissioners. My name is Andrew Cole from the law firm of Vannequart and Cole downtown St. Charles. Glad to be here. With me here is Aldo Batista, Fabian Batista, and Guadalupe Batista, who are sitting behind me. They are essentially Guadalupe is the homeowner with his wife. The Batista family has been here since 2005 in the community, almost 20 years. They've been residents of Campton Hills, so they're not new. They've been moved here from California, and proud citizens and residents of Campton Hills. So we have filed our application for variances for you following what was, as your attorney alluded to, a prior code enforcement action. I just want to start out by indicating that the petitions that they seek relief for tonight has nothing to do with the operation of a business. We have previously agreed, because there was some trucks on the property at one point in time, which was something that historically they've been able to do since 2005 on occasion. There was a citation, and we did agree, as in resolution of that citation, in addition to other points, that one, at no time in the future will any resident or guest of the property park semi-truck trailers, commercial vehicles, commercial equipment relating to the freight hauling business that the family owns, GFP Trucking. It's operated off-site, and so the petition here before you is strictly residential, 100% residential in nature. So we want to dispel any sort of maybe notions that you might have that this is relating to the operation of their business, because it doesn't. So there are some other conditions, but I think that's the most relevant, and that is a condition of resolution of their code enforcement action. So if they were to ever violate that condition, those code enforcement actions could be reinstated, along with all of the other, remedies available under your ordinances. So we take those very seriously. It was a lot of work to get this resolution. We had to make a lot of concessions that were hard on the business and the family. So, but we did, and so we just want to let you know that this petition is just strictly for residential. Secondly, matter of housekeeping, I do have the notices that we sent to all of the adjoining property owners, the certified mailings. I can leave them here if you want to make a finding that they're part of the record, that we gave property owners. There was a sign, and I think the village channel for publication in the newspaper, so.
I'll acknowledge receipt of the certified mailing receipts and copies of the exteriors of the envelopes. These were to property owners within 250 feet of the subject property. Is that correct, Council?
Correct.
And then the village will also include in the record too the sign and a picture dated of the sign that was posted on the property, greater than 15 days and no less than 15 days and greater than 30 days before, or greater than 30 days before the hearing tonight, and certification of publication in the Daily Herald of tonight's.
So the property's at 39 West 910 Old Burlington Road. We're seeking two variances, one pertaining to the side yard and the other pertaining to the size and dimension of the garage. We did contemplate actually obviating the size variance by connecting the garage to the residence. It was something we considered. We actually talked to an architect about doing that. Because I think by connecting either a headway or making it part of the home, the garage is actually similar to some of the other large estates in the area. Then we would be left with the side yard only. But we thought before we went through that exercise, we would at least bring this petition and see what your reaction was on it. I also think the side yard, it's important to note that the existing garage, which has been there well since the 80s, we think, was positioned exactly where the current garage is as it relates to the side yard. So it's not as though the new structure was moving close to the property line, encroaching further into the side yard setback. We built it in the same, we actually built the foundation, and then came in before you, a little bit out of order, but at the same time, the current proposed garage is in the exact location as the existing garage as it pertains to the side yard. The only difference being we moved it to the rear yard to accommodate the additional space. So, this particular petition is really technically like an expansion of a legally non-conforming use, I was trying to label it, rather than a variance, but we thought, let's ask for a variance, because I think it's the safest route to take. But the important thing to remember here is that this side yard encroachment has existed since the house was constructed. I'm not sure how the permit was granted, allowing for the encroachment. The only thing I can think of is that it predated the ordinance. The house must have been built prior to the adoption of the side yard setback because it was allowed to be constructed. So the garage in its current location, in the original location, when Bautista's bought the house, was the exact distance from the side yard as possible. In speaking with Joanne, one suggestion, little background that she had, was why don't you go try to purchase a few feet of property from the association that adjoins our property. So I actually, in the association, a little bit kind of ran us around a bit. They said, we'll go ahead and propose a contract and get the property survey you'd need and try to buy the extra couple of feet from us, but we need something very specific. So we actually took the time to have a surveyor go out. We were trying to buy like a 6-foot by 60-foot area, real small, just to accommodate that side yard setback. And we had to provide all kinds of engineering related documents and presented it to the association board. And it was decided that they just had no interest in selling us a few feet, even though it's part of the common element. They just didn't want to convey either an easement or ownership of a little, we called it the bowling alley strip, but it was a tiny strip of land we were trying to buy off of them. Offered them a good sum for it, and they wouldn't take it. So we're left with either having to dig up and remove the existing foundation that exists, which is an exorbitant cost and hardship on the family, or seek a variance. So that's why we're here tonight. That's some of the background. But we did try to exhaust that before we I don't want to say waste, before we use all the resources of the village to go through this process. We wanted you to know that we did try that avenue and spent a lot of money and time trying it as well. So, all right, now with respect to the side yard, applicant seeks a variance from the side yard requirement to allow an encroachment into the setback. We propose to place the freestanding garage 2 feet from the side yard lot line, which is exactly where the old garage was placed with respect to the side yard, extending it to the rear to accommodate the new size. So that's the first variance pertains to the 10-foot setback, and the second variance pertains to the area, which is to exceed the square footage of a freestanding garage, so as to avoid having to incur the cost of connecting the garage to the residence. And again, the reason that we're seeking to have a larger garage is that Mr. Bautista has accumulated over the years personal tools. Unlike a lot of residents in the village that have services that perform, he has an 1.6 acre, I believe, almost. And he does his own landscaping on site, he does his own home maintenance, he does his own work on his property, and he has his own quite a large lawnmower that he uses to maintain his property. And the garage is designed to house his vehicle, one of which is a pickup truck, and all of the other equipment that he has. It's strictly for personal use, and to rip up that foundation is a hardship. To take a foundation out, fill it, backfill it, and re-pour it would be exorbitantly expensive. So He's looking to store just his own equipment there, nothing to do with the operation of the business, that they operate separately. So, we think the house was built around 1973, prior to the adoption of the ordinance requiring the side yard setback. And, but nonetheless, we're proposing to expand the garage, which is why I think we would need to technically apply. As far as the appearance of the garage, we didn't provide architectural elevations in our application because, quite honestly, we wanted to leave it up to you, to condition it how you'd like to see it. I heard the objection from our neighbor, in the rear yard. We wanna make sure that everyone knows that we are proposing a masonry structure, at least for the first 4 feet, to match the design of the house, with some siding above that to match the color scheme, and a finished roof, and windows, vinyl windows that slide are proposed, 2 in the rear and 2 on the sides, make it look commensurate with the house. And if if this commission wants to propose any other aesthetic elements to the garage, we'd be willing to dress it up with whatever you'd like to see. We're kind of an open book. We did propose some things here in Exhibit C, as far as the paneling and as far as the height of the door and, some of the color matching aspects. But then again, we're not married to any particular concept, so if the commission wants to see something specific to make it look a little more palatable, we're willing to do that upon your recommendation. So, as far as the dimensions go, we show it in the survey there, which is Exhibit A, what we're proposing, and I think the actual dimensions are 34 by 60, and the ceiling height is 16 feet. It does rise to 20 feet because of the A-frame on top, but if you'd like to see it flat, we could also change that and tweak that, or if you wanna make it slightly smaller, we have a few feet we could work with, to make it a little more palatable. And as far as dressing up the rear of the garage so that it's not unsightly, we were talking about it walking in. We said, do you think anybody will come and object in the neighborhood? And, the nearest house to our rear yard was quite a ways. It's not like it's, Fox Mill or something where you see the houses kind of on top of each other. I figured it was at least 100 yards. I was actually surprised anyone would care, but I understand people in their property rights, and they wanna make sure that the aesthetics stay consistent. So we certainly can work with the neighbor to make sure that what's built is not gonna be, objectionable, or if there's additional landscape berming that needs to take place, we could provide that as a condition. We could plant trees as a condition. We think the view will be obstructed, but if there's different landscape requirements in order to balance the equities, we certainly could, live with whatever you guys propose in that sense, and do what we can to screen it. We think it'll be an attractive structure, much like the house, but we understand. So I wanted to throw that out there as a concept. Conceptual design. We did address the elements of the conditional use in the application. I tried to address them in writing, so we didn't have to spend a lot of time. The property is consistent with the use of the garage is strictly residential. It's certainly consistent with use in the surrounding area. Some of the massive homes in the area, it's consistent with the size and dimension of those homes. It's in the F farming district, so we're not proposing any business use that would be out of character. For the community, it's not like we're trying to rezone a property to commercial or reduce open space or create something. And from the roadway, as you drive by, it will look the same because it's essentially in the same location as the old garage. So we think from the street, it would look the same. It would be technically closer to our rear yard, but there's such a vast distance there, and we're again willing to screen it. So we don't think it's gonna affect, it's commensurate with zoning classifications in the general area. We think it's suitable in the general area. It's not unsuitable. You see a lot of larger garages in rural communities. Homeowners have equipment. It's not a situation where Batista family has just, a couple of Hondas. I mean, they've got a sizable amount of equipment that's been accumulated over the years. Lupe's got, you know, a lot of landscaping type equipment and other things, tools that he's had. And culturally, it's something that he retains and keeps on site. So, let's see, the next element, what's the trend in development in the surrounding area, and does this impact the trend? The trend in the area is unquestionably residential and farming. That's consistent with our use since for the last 20 years, is to keep it residential. The family is kind of where everybody gathers for family events, and when relatives and the other family members come to town, they, you know, often will gather for celebrations and family get-togethers at the residence. There's no other use proposed here that goes on, and feel like it's commensurate with the F farming district and the open farmland concept in the area. As far as the third element, how does the projected use comply and relate to the Kane County 2030 land use plan? Obviously, we're not proposing any change that's contrary to the land use plan or the planning objective that's set forth on page 11 of that plan. And again, we agreed as part of the administrative code enforcement action not to park any semi-truck trailers, semi-trucks, or other commercial vehicles of any kind on the property relating to the business. So that's something that we had agreed to in resolution of that case. And that in additionally, at no time in the future will the company have any resident or guest on the property that will store commercial equipment there of any kind. And that activities be strictly residential in nature. So we feel like those uses are commensurate with the Kane County's land use plan, sticking straight forward to residential. I mean, what you have here is a family that just wants to be able to store their equipment on their property and build a garage that can accommodate that. We're willing to dress it up as nicely as possible to make it work for everyone. We're willing to screen it. In addition, from the rear yard, we're willing to take the suggestions from the neighbor if there's something we can do to make it a little more attractive in their view. But we think what we're proposing here is reasonable, and also because it's in the same location historically as the existing garage was prior to it being taken down. I think the side yard setback is essentially grandfathered, although it's an expansion of that grandfathered use. Essentially, it's not something new that we're proposing, we just wanna set that out there. So I think I've covered everything. If you guys have any questions about our application, you know, we're willing to go through it.
I did misspeak, it was, the notices went out to property owners within 500 feet.
That's right,
of the subject
yeah.
property, so, even greater than I said.
All right,
Oh, I just want you guys to know, also one last thing, we did pay, the Batistas did pay the $1,100 zoning application fee, and then the $500 additional fee, and the $1,500 fee to cover the application. So just to bring, they're pretty steep fees, I just want you to know that all of those have been paid by the family. As well as additional fees, which was the $600 survey fee, $400 in postage. So that was all covered as well. So it's been, you know, give or take about $5,000 in expenses just to bring an application before the village. You know, all of that was paid, so. That's all we have. So thanks for your time, appreciate it.
thank you, Mr. All right, we're hearing from, Mr. Vaquero. Did you
Yes.
want to add, you had the pictures or some?
I do
other
have a couple
things?
of pictures. So this is just a couple of pictures that we took. One is from our backyard standing at the ground level. And we circled what you can currently see of it's not a garage now, I don't believe. I think it's just a parking area, right? I think he took the garage down, maybe. And this is from our, so this is the above, so this is from the deck. So you can see, I mean, they're there in the winter and in the spring. You can see through because the berm slopes down, of course, right at our, right at our house. For whatever reason, the association didn't go out to all the way behind, and then there's a pond, okay? So the berm slopes down, you know, you can look at us, we can look at you, and so that's just happens to be, and it's, again, if there's, you know, if there were more evergreens, and if there was a berm, it might be a completely different issue, but you can just see what we can see. What? Well, the structure
The structure going in is awfully large for a garage.
Are there any, questions, by the commission of the petitioner or of the, people testifying?
Yes, please. I have a similar situation, about the same size property. In '85, I had a 24 by 24 barn built, I contracted it myself. It's called a pole barn. I am assuming this looked like a pole barn to me, so it could not be attached to the house. You'd have to do a lot more foundation things to do to the house. How is this considered a hardship to the family? I don't understand that statement. You've used the word hardship a lot. Why is it a hardship? Because on this size acre, for me to have a 60-foot barn to store my equipment, my lawnmower isn't that big. I don't know, weed whackers aren't that big. Unless you're Jay Leno and need a lot of space for your cars, I don't know private storage of what you're going to make it a hardship.
You want us to respond, or?
Yeah, if you want to
Please.
ask the petitioners, please do.
Please?
If you want to, I can respond. Okay, Peggy Sue, right?
Yes.
Okay, so we talked about this a lot before we came in. What is the hardship for the applicant? The hardship is the garage isn't there, first off. One of the hardships is having to dig up an existing foundation that was poured at an exorbitant expense and start over. So that's a hardship that the applicant created. I think another, so it doesn't really count, but the other hardship is the fact that we couldn't negotiate anything to fix the side yard setback remedy with the association. I think that additional fact, the fact that we couldn't purchase the additional property is a unique fact here, and we had an existing structure that was in the side yard setback that couldn't be remedied now because we couldn't adjust the property line with essentially what is open space is a unique fact that I think creates a hardship. But thirdly, Mr. Batista has equipment that he's already purchased. It's been in his family for decades. It's something that he owns. Culturally, this is something that he collects. He doesn't get rid of it all. We can itemize it all for you, but it's right now it's outside, it's unsightly, and to have a place to store his equipment on his property in a rural community is one of the reasons he lives in Campton Hills. So does he have too much? That's subjective, right? Everybody has a different viewpoint of what's reasonable in terms of what they have in terms of equipment. This is what he owns, and he's merely asking for a place to store what he owns indoors. So I can't be the one to tell him, this really isn't a hardship. You need to sell this particular piece of equipment that he uses for this particular job on his property. He does all his own repair work on his home himself. He does all of his own landscaping on his home himself. Culturally, that's who he is, right? He doesn't hire it out. So these are the things he has, And I think that, yeah, I thought about it, I think that creates enough of a hardship for him. And it's one of the unique factors of living in a place like Hampton Hills as opposed to moving to Naperville. So, I think that's about the best we can do to answer that.
My question to you then is, take 8 feet off your building. If you can't get more land, make the building smaller. What's wrong with that as a solution or a possibility? Have you asked them about adding, you guys add on to their berm?
Would you be willing to add on to the berm in the back? Add on to what? I mean, like make the berm larger?
Well, if that was one of her suggestions.
Yeah, we were just talking about possibly evergreen trees. I think if it can be solved with a landscaping solution, I think we would do it.
The garage isn't for the purpose of storing the semis there anymore. We went over that, we're not storing the trucks there anymore. It's more of a luxury for my dad to have a garage that size and be able to have a garage that he can store anything in and have it in a way that it's aesthetically pleasing to him. He's very unique with how he is with our home. I mean, if you drive by it, it didn't look like that 15 years ago. He built that himself, but an architect a long time ago. So over the years, he's building the home to be something what he dreamed of having. So it's not about, we're not gonna use out the square footage of the garage, maybe not, but it's about having the luxury to have the garage that he's always wanted.
Sure, for me, I would love that luxury. I had to obey by the 24 by 24 size.
Right.
What is preventing me from coming into the village once we approve it to you, for me to come in and say, hey, I want another 1,200 square feet added on to my barn, because I want that luxury.
If we were to attach it to the house, would that make a difference?
I don't know what the permits are allowing to your house.
Cause we are willing to pay
Square
whatever it
footage to
is.
your house. And all, but it may not be, this kind of construction, so it's a different issue. But, go ahead.
One question I have though
Mr. Anderson.
is, when you added the second story to the house, you were aware you had to get a variance for the garage back then. So you already were aware that you were too close to the side yard back in 2010. That's the information I have here.
We only had the second story, we didn't touch the garage.
No, but in order to build, you had to get a variance for that side yard.
Yeah,
So I mean, you were aware that you were already, the garage was already in violation, the existing garage.
I'm not sure, I can't speak for that.
And then there was a building behind that that was on the property line. So
The shed.
you removed that.
Are you saying there was a variance granted in 2010?
That's
Yes.
It appears that the county did, when the second story was placed on the home, the county, zoning board of appeals I'm sorry, was it King County? Would have been 2010.
Well-
No, it would have been, Kent
Well,
County, excuse me.
But
There was an application for.
It was
a
still
variance.
through the
Still
village.
no, it's right.
Yeah,
It's
it
a
was-
privilege there,
Ranieri
right.
took care of
Yeah,
that.
it's,
There was a requirement to apply for a variation for that side yard, which appears to have been granted back in the day, for the pre-existing garage.
and one of the dilemmas with all of this, and this has come before us on numerous occasions, variations are supposed to be a hardship on the property, not a hardship to the owner. So in other words, if someone came along, like, the highway commission came along and they condemned a certain amount of, frontage along your property, and now your setbacks are no longer applicable, then that is where it's a hardship on the property. So hardships, meaning it's, thinking from a personal standpoint, that's not what variations are about in and of itself. And this is based on what I've heard from various attorneys that have talked to us through the years, as well as seminars that we've attended. And so we as a commission have faced this on numerous occasions, where it has to be a hardship on the property, which is different than on an individual, whatever the circumstances might be. So that's one thing in and of itself that, is challenging for us, to look at. Okay, any other questions, before we close the hearing? Yes, Mr. Terrell.
Okay, if I could give comment, Well, I'll stand from here if I may.
Sure.
Tonight is about zoning, not aesthetics or design. Regarding the existing foundation, it appears that that occurred prior to the village. But as everyone knows, the village adopted Kane County's zoning, lock, stock, and barrel. So regarding the placement of that garage foundation, one would have to ask the question, did King County give a variation? Was a permit taken out? Was one granted? Or did it simply get put in without having gone through the process? Okay? As was pointed out here, there are 6 criteria that go into a variation. This is legal precedent, King County, this is Village of Camden Hills. There are 6 criteria. It requires for a variation to go through, all 6 criteria must be met. One of those, and key in those, as was pointed out, hardship is on the land, not on the homeowner. If there is hardship on the land, then one can offer potentially a variance, provided the other 5 are met. King County Highway Department, somebody comes in and condemns a piece of road. It could be that there is a natural feature, a lake, a bog, some unbuildable piece of condition that exists, a ravine, something along those lines. I don't think any of that exists. There is no hardship on the land. The testimony has been, it's a hardship for the owner. I would remind this panel that this is not the first time these kinds of variations have come before the board. 2 years ago, a gentleman, similar size acreage on Winchester, proposed a similar sized garage, and the panel and the board ultimately turned that variation request down. So I leave that information for your deliberation.
If I can comment on the condition of the land, I think you can make an argument that the fact that the house was constructed with existing building permits in a manner that already encroached upon the side yard setback is a unique situation with respect to this land. It's, the configuration of the house on the lot is relevant. You can't say that if we're asking for a variance to encroach in the side yard, and we already have a situation where the entire configuration of the house is encroaching already, that's unique. That creates a hardship where we have to live with the existing configuration of the house on the lot. Maybe if that prior variance wasn't granted or the permit weren't issued, the house would be moved to a different configuration where we wouldn't need the side yard encroachment. So at least with respect to the side yard encroachment, I think we have unique physical characteristics about the layout of this lot that came from the prior approvals, which were approved with the encroachment. And I'm not sure whether that prior approval runs with the land or whether that prior variance expires as soon as the garage was taken down. That's an interesting legal question, you know, but at the same time, I made the point that it was constructed this way and it wasn't cited all these years. So I think with respect to the side yard, you could make a hardship argument. On the size of the structure, same thing. I think, you know, we could connect it. The hardship is the cost and expense of removing the foundation that was already poured by Mr. Batista, believing that his existing encroachment was okay and permitted prior to this. That's a unique set of facts, I think, that distinguish us from anybody else just wanting to roll in and ask for a bigger garage. So, aside from those things.
So was not an existing foundation. This is a foundation that Mr. Batista poured.
Correct. He removed the existing garage and poured a new foundation with the same exact side yard setback as the old garage, just with a larger footprint.
Was a permit applied for that?
It was not. We immediately stopped, came in, and asked for the variances instead.
I can speak just a bit to the history from the documents the village has obtained. Back in 2010, when there were modifications to the home, the variation was to allow the existing garage to remain, which was already into the minimum required setback. At the time, it appears to have been 3 feet. It was 0.37 feet from the side yard lot line. At the time, the owner indicated, and it doesn't appear to be any evidence contrary, that, the property was, built back in 1991, that garage was likely built by the prior owner. At the very least, it was built and existing prior to the current owner purchasing the property. So, they were allowed to have that garage up until 2010, to when they had to seek variation.
Did I understand you said three, it's actually 0.3
The prior garage was.
Yeah.
The point garage.
instead of even
Okay.
3 feet?
So that was the prior garage that
Right.
was existing.
Right. But they poured it on the same spot, is what I understood you to say.
The way that I read these documents and based on what has been applied for today, I think that the current foundation would be slightly further into the property. It was 0.37 feet from the property line before, now it's 2 feet. So it actually is further back from the property line.
Mr. Chair?
Yes, Mr. Earl, please.
Couple of comments back, I don't know that I have enough copies, I think you have one. We've heard testimony that the house is in the encroachment, and I think if you look at those aerials, you'll find that the corner of the house is a long, long way from the property line. It does not encroach. Also, grandfathering comes into play. Something is grandfathered as legally non-conforming until it's demolished, and then conformance is required. As we just heard, the applicant poured the foundation without a permit.
I think the existing garage had some structural problems, it was unsafe, that's why they took it down, it was impacted in a storm event.
Yeah, the prior application, the variation was probably looked at more in the light of illegal non-conforming. This would not be considered that, this would be a true variation if it's new construction, even though it's on the same or similar site.
Yeah, we did not apply for an expansion of illegally non-conforming use.
I just have one extra comment. The side,
Yes, please.
the side lot issue for me is not an issue for me. I really couldn't care less how close it is to the side of the association's property or not. However, for me, the biggest issue is size. And I think you're right. I think if it's 24 by 24, or it's whatever if there's a standard, or if it's 900 square feet, or it's a variance for 1,000 square feet, I don't understand. I understand you have a lot of things, and I'm not trying to, you know, people have the freedom to have what they want. The things that they own, I get it. I'm not trying to, even if it was, you're not running the business out of there, that's fine. That's good, but if you were, you have a right to make money. I have no problem with that. What I do have an issue with is just the sheer depth and breadth and height of this thing, that it doesn't have to be that big. And that's where the biggest concern, from the neighbor behind, right?
It's like another
And,
barn.
You know, and there are absolutely barns on Old Burlington, and they're probably they have to be grandfathered the size that they are, and that's fine. But I do understand what you're saying, is if you tear down the original garage, you suddenly become, you know, you have to comply then, my understanding, with the new set of codes. And the biggest problem for us is the size. You know, it seems that if it is a 2,000 square foot footprint, that's huge for a garage, to me. My garage is, 3-car garage, so there's only certain things I can compare it to, but isn't that about what it is? We're talking about almost 2,000 square feet of the footprint, plus a 20-foot height. So that's where I think it just, and if you can attach it to the house and there's nothing that we can do about it, that's nothing we can do about it, but this is just, it's just tough to be able to accept such a large garage.
Jerry?
Yes.
I do understand correctly, please, that we have not changed size requirements for this compared to when I built mine in '85. So it's not new. They've been in existence for a long time.
I would have to look at that from a very detailed standpoint to determine the history of it and all. But most of these, sizes were adopted from the King County Code. And so whenever the King County
Right.
Code 2007 might have changed things. All right, so you'd have to go back at least to 2007, and look at the county code and see whenever changes were made at that time, to be able to answer that question accurately. But, all right, Mr. Dragood, Mr. Dragood, do you have any questions of anyone?
You know, Mr. Batista is willing to compromise on the size if you have another recommended dimension that you find palatable. Yeah, we're willing to, whatever makes it easier, whatever number anyone agrees on, but obviously like the 60 feet, they have an issue with. We're not trying to argue against what they like to see, what they don't like to see, so we're in agreement with whatever number we can all agree on. We're willing to do that too. We're not trying to say this is what we want and we're gonna do everything possible to get it. We're willing to listen, we're not trying to either to argue or, you know, they're probably gonna be living here for a long time as well, so we're trying to make it easier for everybody.
Well, across the board, it has been 900 square feet for a lot of this size for all the properties in the town, in the village. And in effect, the township, since the rest of the township that's not in the village is still under the Kane County Code, so it's nothing new, that's been around, in and of itself. But, any other questions? Anybody? Nope. Okay. All right, any other comments or anything?
Just to flesh that point out for a bit about, limiting the size of the variation, I indicated in my memo that that is an option. If that's something that the commission would at least would be considering or would wanna discuss, I might ask the applicant how small, let's say, of a building or structure they'd be willing to construct, so that you can then discuss that internally. You still have the setback requirement, that, may make things difficult, but you may wanna know that before you discuss.
Chair?
Yes.
If I may, I think the due process is, you have a petition before you, and the recommendation for or against is based on that petition. If there is further negotiation, adjustments, et cetera, then that historically has gone back to staff for a settlement and comes back to the plan commission for its review as presented.
And again, it ultimately does go to the village trustees to make.
And you have two variances in there to recognize, it's not just size, but you also have, as was pointed out, a foundation was poured after an existing non-conforming was demolished. And without a permit, without review, a new foundation went in, replicating, even narrowing that variation. And so there's 2 points of consideration that should go back to staff.
Well, respectfully, to provide the applicant with proper due process, the zoning ordinance itself indicates that the PZC may allow for a grant of variation that is less than requested when it has been decided that the applicant is entitled to some relief of the hardship, but not the entire relief requested in the variation application. So I'm reading that from section 13.5 D3E. So the reason for my statement was that because the applicant indicated that they might be comfortable constructing something less than what was applied for, you might want to ask them what they would consider constructing that would still require you to provide a variation.
And if I may,
and if I could please, because we have a chair here.
Yes.
Sure, thank you. And I'm not the chair, so he can tell you to speak or not speak, but I'd like to finish how
No, go ahead, please
advising
finish.
my client. If you wanna hear from them what they would consider, it might be relevant until, while we're still in the public hearing, before you go back to speak to each other and we have to close the public hearing. That's the only reason.
Jerry, may I ask the attorney a question?
Yes.
In past reviews, if it's setting a precedence, because if we approve it regardless if it's over the ruling of what we normally have on the books, that opens the door for me coming along and Joe Schmo coming along and everybody going, well, he can do it, why can't I do it? So it's changing the rules without not changing the rules. So how legally is that difficult?
Oh, and that's not what I mean, and I agree with you, I mean, every case is considered on an individual basis, and certainly people will discuss precedent no matter what you do. You have an interesting situation here because you have a setback variation and you have a maximum square footage. If the applicant were, for instance, and I'm just guessing, if the applicant were to say, well, we'll meet the maximum square footage requirement, but we would ask for you to give us the setback variation. You're gonna wanna know that now before you close the public hearing, because they can't discuss with you after you close the public hearing. So you might wanna ask them some of those questions first, and then if they say no, then you'll know before you close the public hearing.
Mr. Tyrrell?
Yeah, just one final thought to bring it all into perspective. The consideration is based on 6 criteria. Findings of fact are based on 6 criteria. Hardship with the land is one of those. It has never been demonstrated you have hardship with the land. If one of the 6 fails, all 6 fail. The whole petition fails. So that's something I leave for your consideration. I agree with Commissioner Seehafer here. We've been through this for 9 years on putting the zoning together. 9 years. Most of it is still lockstep with King County. However, as I mentioned, Winchester got turned down. It was a similar size garage on a similar size property, and it was turned down because it was not a hardship on the land. You have to consider setting precedents, because once you break that precedence, you now open all kinds of variations for the future.
I'll just respond, I don't know whether. Yes, sorry. I don't know whether the Winchester case involved an existing structure that was already constructed within the side yard setback and involved a prior legally non-conforming use or prior variance granted by a municipal body. Every zoning case is different. So I do think we have a hardship on the land here. We have a unique set of circumstances in every zoning case, and this is truly unique because the existing garage is erected in the exact location as the prior garage. I also think that you can negotiate conditions with an applicant. I've been doing zoning 25 years, all over, and I've been in situations where conditions are often negotiated during a hearing. You don't have to reapply and go back through another administrative process with a brand new application and then get another set of staff comments and staff memos and pay another $6,000 in administrative fees and renotice the adjoining property owners. That's absurd. We'd be willing to cut down the size of the property considerably by half, even meet the requirement perhaps if we could get the side yard variance, which is a variance that's already been in place. We're proposing, let's say, a 2,000 square foot structure here. We get the exact numbers. Just read it right into the record. It's 2,040 square feet is the garage. Mr. Batiste would be willing to go to 1,020, for instance. Something much more reasonable. Would agree to landscape the property to add some additional screening if that's what a condition is recommended. So we ask you that you consider these items as you move forward.
Jared?
Yes, Commissioner Shue.
Can you tell me if you say that it's a hardship and that if you would have gone along with getting your permit, you would have found out that it was not, and you would have had doing just this permit process for the setback, not for both. So the hardship is on, in my estimation, looking at, you caused the hardship by putting something down that wasn't correct in the first place.
If Mr. Batista should have applied for a permit before he took his garage
Right, and then he
down.
would have been aware of the setback, he then needed to get the variance then, correct?
Potentially, yeah. He
Okay.
believed,
Okay.
right or wrong, he believed that he could rebuild in the exact location. So did he create the hardship? In part, but I also think the hardship exists because the existing structure was already in the setback.
Okay.
So that's a unique situation. You know, when you look at hardships on land, you look at the sightline, you look at wetlands, you look at, is there a configuration of trees? Is there a topography that causes a slope where something has to be built in a certain location? The fact that the configuration of the entire development is pushed towards the side pursuant to prior approvals before the adoption of the ordinance is a condition, physical condition of the development. It's physical condition of the land, it's unique. So I think you can consider it. As far as giving it weight, that's up to everybody to decide, but I think it's a unique factor and shouldn't be ignored, so.
So, a question, so you are willing to meet the 900 square feet?
Yeah, we're willing to do the 900.
If we can get the side yard variance in the same location as the house, the garage is better.
Is that something that you could live with as a neighbor?
Well, sure, I mean, 900 is what is allowed, so I'm not gonna object to something that's already allowed, that's fine. We would,
And we're still willing to, like,
yeah,
tie any landscape.
we could, yeah, if you would do something maybe around.
Cause I do know, like, when we're pulling into the driveway, those LED lights are for sure pointing to your
Sure,
kitchen,
sure.
probably
And,
eating dinner.
right, I mean, it doesn't have, yes, that'd be fine.
Yeah, and I think the garage would help blocking,
Right,
blocking the cars
that's-
coming into the driveway too.
So I don't know if we withdraw the application for the size variance at this point, having agreed to meet code, or just proceed on the side yard variance, I think, at this point.
The hearing started, so it would indicate in the minutes that you withdrew it. There would be no action by the commissioners on that application if you're not seeking it anymore, or
Okay.
that specific variation. And then they would just discuss the other variation.
I think we're willing to do the 900, so.
So we'll withdraw the size, application.
And then I would probably discuss any, conditions with the applicant too. I know the conditions that were indicated in the packet, they've already agreed to. But I did hear tonight, landscaping in the rear yard, so screening landscaping.
Yeah, I think the conditions would be, we would match the aesthetics of the home. We could add masonry up to the first 4 feet, I think, to match the aesthetics. We could color match the rest of the siding. We could add the vinyl windows per the plans.
Okay.
We could add landscaping, screening in the back, evergreens, whatever you guys would. I'll leave, I mean, so whatever conditions you'd like.
The material that was submitted showing a pole barn, from Menards, that's not the design.
No, we're gonna match it with siding. It's gonna be a wood
So
structure.
is it a pole barn, is it a steel barn, is it?
It's a wooden structure with siding and brick.
Okay.
But it's on pier pads? It's on pier pads there, or you've got the foundation already poured, that's what it's sitting on?
Yeah.
And that means, okay.
Yeah, I mean, is the foundation, meet code, that would be the first thing
Right.
as the building inspector. you
Exactly.
could Check that out, so that would be a factor.
Because when I did it, we had to go, I kept going back, they wouldn't tell me what size pier pads I needed. They said, you tell me what you're gonna build and we'll tell you if it's okay. I thought, this is but,
We could agree as a condition, we pass all building codes.
okay.
The standard
That's-
condition I usually add or recommend is that all work be done conforming.
So is that
Pursuant to a
a-
permit, all inspection,
Good.
building codes, et cetera.
Is that a frost wall then that's in there currently?
I
Is there a
believe
frost
so.
wall
Yeah,
around the perimeter?
I believe so.
I think so.
4 foot down, frost wall.
Thinking so, and,
I can't tell from
Is
the
it-
picture.
Right.
Exposed.
Right.
Is that the material that gets stapled on the inside?
No,
This
the
is- you have
foundation.
Like a foot, like a
You're
foot
existing.
deep enough that it won't be affected and lifted by frost. So underneath the main foundation, you have a footing.
Is it just a pad or is it?
Inspected.
If your code requires it, we'll do it.
yes, it has to
There'd have to-
be, it
there'd
has
have
to
to
be
be a-
inspected.
We would have to go full building permit application and have a foundation inspection and go through every step of the process once a year. We didn't wanna go through all that until we knew what we were gonna build, so.
And the, the hearing's still open.
You need to sign in, with your name and all, and then take the oath of, your testimony. What's your name, sir?
John Saucer, 876 Old Burlington Road, I'm a neighbor to
Yes.
the.
All right, if you swear Mr. Saucer in.
Swear to tell the truth, nothing but the truth?
Yes, sir. I apologize for being late. I just want to give some input, but ask a quick couple questions. So I'm sorry, I'll try and be as brief as I can. What's the process that this happens here? Like, are we trying to like actually make a full decision and pass it and they're stuck?
No, this is a recommendation to the village board to approve or not to approve.
Okay.
And then they'll make their own decision. But so this is where we're getting the facts assembled and explaining to the petitioners that this is what the basic code calls for. And, they have to make a case as to how they can fit into that code with what they wanna do, and all. So that's the principal thing. So what are your comments?
All right, so there's gonna be a little give and take here so you're now thinking you're going to shorten or make it smaller to meet the 900 square feet requirement. Are you going to try and essentially a rectangle? Are you gonna shorten it but try and keep the 3 sides to minimize your cost, but still are requesting the variance for the side yard setback? Okay. I apologize. The meeting was the last month, and I know there's been some change in the staff. I called this, 3 different times, I emailed 3 different times, and I couldn't get anyone to even explain this process to me, and then the meeting was canceled, and no one even told me about it last time, so I apologize for being here late. Sounds like they've made a huge consideration for making the size smaller, and I certainly understand the whole consideration of, is it precedence, is it not? Since they shorten the size of it, as it's a side yard, obviously, all the factors take into account. If there was 5 houses right next to them, then it might be a whole different scenario. But seeing as they're next to open space, it's gonna be open space for eternity, and I don't think anybody outside of this room, a month after this is done, is ever gonna know that encroaches the side yard at all. So I don't think it's gonna set any kind of precedent, because every case is a by case, basis. I would say, give them the variance and recommend it to the village board as far as that variance goes, since my opinion as a neighbor.
Okay, with that, are there any other comments? If not, we'll go ahead and have a motion to close the hearing.
So,
Second.
Commissioner Anderson moves. Commissioner seconds, all in favor, say aye. Aye. Same sign opposed, motion carries. All right, hearing's now closed, and that will allow the commissioners to discuss, the things we have heard, and all. Start with Mr. Dragoo, any comments, thoughts, to get us started on?
Well, I'm happy that they're reducing the size. I'm not sure that the side yard issue is as big of an issue, as I said, excuse me, it's facing open space, so it's not really gonna impact anybody. I don't really have an issue with it.
It sounds like they wanna be good neighbors, and that was what eternity is gonna leave for you guys, but we're also looking further beyond this group of bodies that are sitting in this room, is that, did it impact the size? It makes it more fair. Then I come in with my excuse to why I want a bigger barn, and it fits better. It's something I would consider, thinking that it's, should be approved because of but I would like to see why the plat and make sure that that foundation is absolutely solid.
Commissioner Anderson.
yeah, I think, because the village granted a variance in 2010, I think we probably could live with that variation at this point, as long as it's not encroaching on the property line. And I don't know, I haven't seen the exact numbers or anything, but I don't know how close it is. You said 2 foot to the property line.
It's currently proposed 2 feet.
Is there any difference if one goes from, using the 900 square feet, but making it a different shape and coming a few feet farther away from the line?
Well, that's a possibility, I guess they'd have to propose something, but if we come up with, I'd be okay, with obviously 900 feet is within our.
You're right,
so.
right. So an issue.
The idea is to cut the cost down, but come
Yes,
this way.
and then, but if, see, 900, 10 by 90, 20 by 45, so if you came in, what's the setback required to be, 10 feet? So, I mean, one way would be to, use the existing foundation, just come in 10, and now you have a nice patio out there or something to the side. I mean, you want to have some width, obviously, for certain types of storage, but, if one designed it properly, could all this be avoided?
Well, a permit would have
And you
avoided
build,
everything.
so we got experts here, know how to build.
Well, I think that's up to them though, as far as whether they wanna move the building in.
Well, that's what I'm thinking.
Cause I'm not sure if the foundation can be used that way.
You can't add on to the pad that's already there.
That's how the house is looking.
I mean, make it stack.
You move it to the right, then it's like garage overlaps the house.
It's proposed as 34 with
Right.
60 length, so I imagine.
So,
But you would prefer to keep the 34 feet,
Just,
the width,
I think the way it
and
looks
then
right now
shorten
from
the
the
depth.
front, like if you look at it from the front, it just looks like a proper house with a garage next to it. If you move it 8 feet over, then the house is gonna be overriding the garage.
You're only tearing up one wall of the foundation.
well, it's not, you're making it a little bit longer and a little bit narrower, that's what I'm thinking. See, if you make it a little bit narrower, and then you make up for that loss of square footage by making it a little longer, and it still falls under 900 feet, then you have this concrete patio to that side. That's just what my mind's just thinking, and then you don't, and if you're back far enough, if you want to, cause let's see, how close is the existing new foundation right now?
2 feet.
2 feet, so you technically have to go in 8 feet, so, alright, if you did that, you'd get down to, if you were a 30 by 30 building, you'd be a 22 by, 34, something like that.
I understand, but if the foundation's already there,
Well, is it possible to reinforce the foundation where that wall would be? Could you put in a secondary wall? So here's your existing foundation, you wanna narrow your building, and so you lay a foundation here.
technically no.
Okay. And he does concrete, so.
Well, I mean, you're creating a frost wall,
Yeah.
is what you want.
All right,
you wanna have.
no, that's good enough, I just wanna say, so, cause I was trying to see if we can get around to even have to worry about a variation if we, build it.
I
at 10,
understand, but
at 10, yeah.
I don't know their design of the foundation that's
Right.
there, but,
Yeah.
Would it not be logical to see if the foundation is approved at this point? As it sits, before we think about approving it, if it's not even approved, the way it's been poured?
It still has to go through the approval process, so if the foundation was not built properly, it'd have to be rectified.
Right, the variations, it's effective for 180 days. Building permit has to be applied for, so 180 days. I imagine they'll want to apply for the permit before then, and then if throughout that process, they determine that they can't use the current foundation, because it doesn't match.
Is there any
building
problem?
code, then they would have to come back to
Is
the
there any,
board for an extension.
is there any problem with them if they had a 2,000 square foot piece of concrete, but zoning only allows 900 square feet, is there any problem with that remaining concrete out there if it's used as a patio or
Building.
pickleball court,
Sure.
whatever?
I mean, if you're approving the setback, if you're approving the setback and the remainder of the structure is used for something different that would not require a variation, building and zoning officer would be able to advise to that. It may require that.
Cause the real extreme would be, the real extreme is if you build something and and you didn't get a permit for it, you have to tear it out. You know, so that's where, you know, I just wanna make sure if they have any extra concrete there, that it's not an issue for them, because that would obviously be an additional cost, but if,
The staff would advise on that.
you know,
Right,
so
that's up to,
that's,
that's up to
That'd be
the,
understandable.
yeah. so
build that
that's-
department.
Yeah. That's
So
where.
it's really not an answer we could,
Right,
I mean,
right.
the owners may decide to change it, you know,
Right,
completely
right.
change.
No, I understand
so.
that.
For them at this point, the applicant, if you're considering the variation for the side yard, it's would be for them to have that positive recommendation. Because if you made a condition that they could have a smaller sized building, but it had to be shifted more inwards to the property, then they could have an issue with what's sitting there in the side yard. They'd absolutely would have to remove it, but because it's sitting in the side yard. There could be other portions of the code that would require them not to build anything, in your side yard. You can't, there are other things you can't build in your side yard, in addition to a detached accessory structure, so, they can work those things out with staff as to what the remainder of the foundation, if it has to be removed.
No, I'm just trying to keep it so they don't have to
No, I
come back.
understand, yeah.
You know, but anyhow,
The pad is already poured at 60 feet?
I think it's just a footing, right? Is it a footing? It's not there's the whole pad poured?
Yeah.
The whole pad is poured? Okay.
Well, no, it's just the,
Gravel.
Yeah, it's just gravel inside.
Oh, okay.
Right, it's just the
It's like-
exterior footing,
yeah.
that's my understanding.
Okay.
Okay, well, then, that is, if there's not a pad,
Right.
then one could manipulate it and all.
Sure, it's all
Right.
about money and.
Yeah, I guess I don't understand, because again, going back to my property, I've got a 40-foot garage. It's long and narrow, we stack things in it, we don't drive in a 40-foot width. I don't understand the aesthetics if you're saying it's wide, all you're doing is putting that building in there. You're not shifting it, you're using the pad that you've already established. And you're just cutting off side, it's like a cake.
But it's not a pad, it's just the walls.
Right, but the building
But as
itself
far
is
as
sitting on
general,
that pad,
yeah,
right.
yeah,
I
that's what you're
mean-
saying. Yeah, that footprint.
So you wouldn't have to come back for either thing if you're meeting both requirements.
Yeah, so that would be the risk you would take, cause if whatever recommendation we, make, the village could go against it, even if we decided favorably.
Right.
And all, and so you might, so I don't know, well, you could still always go back to, okay, we'll just use a certain portion.
Yeah, there are absolutely times where I'm sure you have approved, variations or special uses or wherever they might be, and then the owner or developer decides not to build. I mean, it could be a combination of can't get the financing, or they decide they don't wanna do what they thought they could do before, so that could very well.
Well, all right, any thoughts, Mr. Dragoo, Commissioner Dragoo, about what you would see doing then,
I mean, if
proposing?
they already agreed to the 900, if they would agree to, excuse me, as you said, lengthen the building and cutting down the width, I would have no problem with that.
Yep, I agree. I mean, it seems.
Yeah, I'm sorry.
No, it just seems logical to me to not have to keep on extending your time that you wanna do that.
Well, I'll go back to what I said earlier, since the village already granted a variance on the side yard, I think we should live with that. As long as you meet the 900, and, it sounds like you wanna make the structure similar to the house. And then whatever landscaping or whatever you'd like to do, that's up to you, to be a good neighbor. But that's what I can live with.
All right, does anybody what are your thoughts about that in terms of, cause we wanna get on to the point where we either formulate a motion or something, but what do you think about going ahead, since the variance was granted X number of years ago? 13.
I have a hard time approving it if I don't know what is down on the ground right now is acceptable.
Well, we can approve it,
with
but the
that.
building department
Right.
has to determine if what's there is okay or not.
Right.
Alright, so, and if they don't wanna go to the expense of redoing it all there, then the variance would not make much of an issue or an additional difference, I don't know.
It would expire if they didn't build, if they didn't
Okay.
proceed on the permit.
Okay, so,
Unless they sought an extension.
okay. So would say, go ahead and allow the variance based on the, the principal only application petition. Do you feel comfortable with that kind and Commissioner Webb?
I'm gonna abstain.
Okay. If we need.
You need
I don't think,
four.
yeah, I don't think you can do that.
You don't think I can abstain?
Well, you can vote no, let's say.
You only abstain if it's a personal issue or, so you're here to vote.
Of knowledge of, I'm voting yes to something I don't have knowledge of.
Well, the building department can block it.
That's up to the building
The
department.
building department blocks
All we
the
are
fact
granting
that.
Is just the variance itself.
For the side yard.
Right.
Yeah.
That's
But
all.
if our excuse for doing that is the fact that the pad is there and it should be okay, I just wanna know that it's going to be okay. Cause we've done that before, but we want it in legalese that they're held to it.
The condition that I would indicate if there was a favorable recommendation on the setback would be, that all work would be performed pursuant to a permit, as issued by the village and or any other applicable authority, and would meet all building requirements both in, any applicable building codes that have been adopted by the village. So theoretically, could they, the applicant come, with their variation approved by the village board, come to the, building department here and the building department say, well, what you already have there is not, it can't meet X, Y, Z. You might have to make some modifications to it, that's possible. I know that the applicant has spoken to the building department already and has discussed what's already there. I can't say whether or not it meets everything right now, at all the requirements right now.
Yeah, I mean,
Okay,
if it doesn't
if
meet
they
the
meet all the
requirements,
requirements, then yes.
Yep, and that would be in,
That's,
That's
then I
almost
would say yes,
inherent.
okay.
then it's almost inherent that they
Okay.
have to, otherwise.
Yeah, the building department, they would have to meet those, whatever they ask for.
Okay, I'm just not going on someone's word that we're gonna do it this way.
Right.
We're going on the fact
Well,
that they are.
I mean, that's
held to
that was a point that I was a little bit concerned about, is if you were to approve a large building.
Mhm.
And yes, it won't be used this way, it won't be used that way,
Right.
but what happens with the next owner
That's
who
right.
buys it?
Exactly.
Because unless it's a special use, it expires and the building's still gonna be there, so that.
Unless they
you
make
know,
any alterations to the property, and certainly to that building itself, I mean, they can still sell the property
Mhm.
with that setback encroachment, and it'll be indicated in the title
Mhm.
search, but, if the title agent is looking thoroughly through it, they'll find a copy of the ordinance, cause it should be recorded on title.
Right.
Okay.
Commissioner Dragoo, would you like to make a motion?
I make a motion that we approve the side, excuse me, side yard, variance, thank you. But based on the fact that everything else comes back clean, as far as the building department and everything.
I'll second.
So it would be a setback variation to 2 feet in the side yard for a detached accessory structure, with the additional conditions indicated in the application. And then what we heard today on the record, just in summary, additional landscape, screening landscaping in the rear yard, that the construction would be of a wooden structure with siding to match the primary residence, masonry, construction on the first 4 feet from the ground up. That all work on the property or on the detached accessory structure should be performed pursuant to a permit and meet all building requirements as adopted by the village of Canton Hills. Is there anything else? I'll add these all to the findings for you to review next week.
Mr. Trill, comments?
Just point of order, the motion was made to approve, as was stated before in this process. It's a recommendation, not approval.
Yeah, not approval, but to recommend
recommend
to
the
approval.
approval. Variation.
Variation, yes. So, it's one step of the way. All right, so with that, any other we have the motions, first and second, do we have any other discussion? All right, with that, all in favor of the motion, say aye.
Aye.
Aye. Those opposed, same sign. Motion passes. All right.
It's your time.
Certainly.
Thank you.
You guys are even good neighbors,
Well, that's
right?
why they-
Yeah, of course, good way to meet your neighbors, huh?
Oh, yeah.
No, it's okay. No, it's okay. No, no one does.
Nice looking.
Yeah, no, I'm kidding.
Next meeting.
You have to wait on it. We'll just get a sign.
That's it.
That was to say.
I mean, we can. Appreciate you coming in. Fourth Monday. I mean, everyone's good. You guys are all good. Yeah, I hope it still works. No, it's okay.